be looking at today. Today, we'll start with ITAR. So we'll cover ITAR jurisdiction. We'll move on to commodity jurisdiction requests, ITAR export procedures, ITAR export licenses, and then we'll move on to OFAC, Office of Foreign Assets Control. We'll look at sanctioned countries, sanctioned parties. Of course, we'll also look at penalties, right? Because we're all here to learn how to comply so that we don't end up with even an accusation of a violation. And then at the end, I'm going to share some tips for ITAR and OFAC compliance. Okay. Now, I did want to do a poll, but I'm realizing I'm not actually sure how to do it. But what I'd like to do, I'm going to try anyway. I'd like to ask you, if you look at the bottom of your screen, there is a reactions bar that comes up. And in it, you'll see that there's an option for raising your hand and other things. And one of those things is a green checkbox. And I'd like to see how many of you are involved with ITAR. And Tony, as a co-host, I'm going to need you, if folks, if you could just click on the green check mark there. If you could read the number aloud, Tony, I cannot see it with the presentation up. Just
sure thing.
Folks, a moment. If you could please check the green box if you're involved with ITAR, just to get an understanding of how many of you might find this particularly applicable.
So far, we have 23.
23, okay. Well, I'll tell you, for those of you, because that is about, I think, somewhere around 20% of you. There's some goodies at the end. So for everybody else watching, you'll be invited to get your hands on those as well. Okay, so starting with ITAR. First, in terms of, what is it? So it provides an export controls regime that applies only to specific items, related technical data, and related technical assistance that are identified in what's known as the U.S. munitions list, or the USML. This is in 22 CFR 121.1, or in ITAR part 1211. And this is a positive list, which means that an item or related technical data or related technical assistance is not controlled under ITAR unless specifically enumerated in the U.S. munitions list or described in a catch-all paragraph that specifically incorporates specially designed as a control parameter. We have the Directorate Defense Trade Controls, or DDTC controls, along with the USML categories. DDTC ensures that commercial exports of defense articles and services advance U.S. national foreign policy and security objectives. So you can see they're broken out Roman numerals 1 through 12 for the DDC. I'm sorry, 1 through 12 on the left side, and then 13 through 21 on the left. Firearms, guns and armament, ammunition, launch vehicles, rockets, torpedoes, explosive propellants, surface vessels of war and special naval equipment, Section 8, aircraft and related articles, personal protective equipment, military electronics, toxicological agents over on the right side, spacecraft and related articles, nuclear weapons. I know from sitting in an office and seeing the list of these things, it's like, okay, so this is such and such, fine, I'll look here to classify it. Do I need a license, et cetera. But last summer, I attended this conference, this defense conference in Athens, Greece, and to actually be then with the gear, models with machine guns, different demonstrations of certain amphibious vehicles. I mean, the types of things I saw from the drone technology, what have you, I think we're somehow a bit desensitized just sitting in our, offices with the nice views or in the warehouses going through things versus actually seeing them up close and personal, which presumably some of you actually do. To give an example, talking about aircraft and related articles, we have quite a bit of aircraft manufacturing where I live in Connecticut. Category 8 is broken out into aircraft, whether manned, unmanned, like drones, remotely piloted or optionally piloted, as follows. So bombers, fighters, fighter bombers, and fixed wing attack aircraft, turbofan or turbojet powered trainers, attack helicopters, and then of course the parts, components, accessories, and attachments associated with the equipment as follows. And then it gets into more specific items. Under, at the very bottom, this point 1, H11, has technical data and defense services directly related to the defense articles described above in paragraph A through H of this category. Technical data can be something in our experience that we have found companies are overlooking. Technical data may be something that, makes sense in general in the office, what have you, but questions can come up in terms of the who has access to this data. And I'll talk more about that when probably in the OFAC section. So commodity jurisdiction requests. These are requests that are made and they assign DDTC control or they remove it. Of course, if you obtain DDTC control and you go to remove it, there is a heightened level of scrutiny and a high burden of proof. But they are binding and authoritative. They also, you should note that once it's requested, then ITAR jurisdiction is presumed. Now, regarding ITAR export procedures, ITAR exports require export licenses in all cases unless a license exemption is available. And multiple license exemptions are sprinkled throughout the ITAR. They are very narrowly construed, but you'll see the note down here. DDTC plans to consolidate license exemptions in one section of the ITAR. And in fact, they did go ahead and do that. So there was an interim final rule published September 6th of last year. That made it effective back in March of this year, March 23rd. And then in February of this year, they had the final rule, which made the interim final rule with a handful of changes, the final rule. So this is now incorporated, these license exceptions. So what is an ITAR exemption? Well, it's express language in the ITAR that negates a need for a license. So it's available again in very narrow factual situations. And the exemptions are limited in scope and have narrow application to defense articles, technical data, defense services, and specified combinations of these above. In terms of who can use an ITAR exemption, the exporter and all parties must be eligible. And so ITAR sections 120.1D, section 123.16A, these relate to eligibility. The exporter must also be registered under the ITAR, and those provisions can be found in 122.1C, 123.16A, and 120.1C. This is all 22 CFR, okay, is where you'll find these. Now, ITAR exemptions are not always available. So no exemption can be used for ITAR exports under section 126.1 to prescribed destinations. And some exemptions cannot be used for exports requiring congressional notification, exports of MTCR articles, or exports of SME. And the downside to using an ITAR exemption is that every exemption requires that specific criteria must be met. If the criteria are not met, then the license exemption cannot be used. If you use a license exemption that's outside its intended scope, then an ITAR violation will result. So you want to be very careful that none of the factors that caused your company to get an exemption has changed. Some commonly used ITAR exemptions include the temporary import license exemptions, the exemption for re-exports to NATO, Australia, Japan, New Zealand, or South Korea, an exemption for components or spare parts less than $500, an exemption for public exhibitions or trade shows, and the ITAR Canadian exemptions. Now, remember, if no exemption applies, then you need to go ahead and apply for that license with the DDTC. So ITAR licenses, the products subject to ITAR always require export licenses unless an exemption is available. And there are multiple license formats, some of which some of you are familiar with: DSP 5, 61, 73. Then there's the TAAs, the MLAs, and using DECCS, which is the Defense Export Control and Compliance System. You use that to apply. In that system, you have access to registrations, licenses, advisory opinions, and commodity jurisdiction requests. Now, the DSP 73 and 61 licenses mentioned on the last slide, they relate to temporary exports. And I want to point out that carnets are irrelevant, as carnets are for duty. Carnets are sort of like a passport that travels with your cargo. We had a client, they had an art collection that was being exhibited around the world, and they would use the carnet to enter a country with the merchandise, and they never had to pay, right? They had certain stamps, et cetera, that went into the carnet. But when they left the country to the next one for their exhibition, with the carnet, they were not subject to paying customs duties. Of course, they came to us because what was supposed to happen didn't happen, but ultimately we helped clear them of about $500,000 in duties. ITAR license agreements. Okay, so I mentioned TAAs previously, technical assistance agreements. These grant a right to disclose technical data and provide technical assistance. No manufacturing or production rights are provided, and it's up to a 10-year term that the TAA, is applicable. Now, these are specific to the country, to the buyer, to the end user, the product and purpose, and it must be executed by both the US party and the foreign parties. There's also the MLAs, the manufacturing license agreements. And what these do is they grant foreign persons authorization to use technical data in manufacturing defense articles. They authorize a US person to provide technical assistance. That too has a maximum term of 10 years, and they are specific to the country, the buyer and the end user, the product and the purpose, and also must be executed by both the US and the foreign parties. In terms of turnaround time, how long can you, or will you have to wait? Of course, everybody loves to ask this question. And unfortunately, with the government, getting an answer from the government will vary based on the agency's workload. And like several things with other agencies, including OFAC, a license is not a certainty. So, I understand it's hard for companies to plan for all sorts of reasons when you just don't know how long it's going to take. But at the end of the day, they don't promise you that they'll give you your license within a certain time frame. And even if they do give you a license, they can have certain provisos. So this would be a limiting condition placed on an export license or other approval, such as an MLA or a TAA, which qualifies the approval, which is granted by the DDTC. So qualifying means putting a caveat on it. So for example, yes, you can do this. However, there can be no detailed design data or there can be no source code. In terms of ITAR export procedures, you can find if you're trying to export something, you're going to need to put the export on hold until your license is received. Once you get it, you want to go ahead and review the license and the provisos upon, receiving it. You want to make sure, hey, are there certain conditions? Did we get everything we wanted or only part of what we wanted? You need to apply ITAR destination control statements to your invoices and your transportation documents. And also, license applicants are responsible for compliance with the license terms and provisos. Of course, where somebody new joins your team, your compliance team, you want to make sure that they get a chance to go through your compliance program as part of your compliance program, that there's training in relation to all the licenses, what caveats there are when they can and can't do something. And also just so that they know, oh, hey, this has changed on the end user, for example. Is this going to impact what we're doing? Once you can stop and at least ask the questions that you need to ask. Importantly, you want to remember that the government views ignorance of the law as no excuse. This is actually the first statement I was told, a couple decades ago in law school with respect to the law. Basically, if you don't know it, that's not their problem. And so ITAR applies what's known as a standard of strict liability in assessing violations, which means there's no margin for error. Okay. And this notion of negligent versus criminal, you just considered guilty, right? So US exporters cannot avoid liability for export violations by shifting them to a freight forwarder or a foreign buyer, which would be in a routed transaction, which would not ordinarily occur in an ITAR transaction anyway. But in general, for everybody participating, most of you are exporters. Okay, Tony, can we do the poll again? I'd like to know how many people are involved with the OFAC and export controls in OFAC. Folks, if you could go back down to the bottom of your screen where the reactions button is. When you click on that, you'll see that there is a green check mark. If you could go ahead and check that, please. And then Tony, well, hopefully you cleared the prior poll, but if you could, give folks a few seconds and then let me know how many have clicked it.
Okay, sounds good. All right, we are at 29.
29, okay. So again, about a third, and I'm presuming some people haven't participated in this, maybe they're making breakfast. But the Office of Foreign Assets Control, their regulations, they're an export control regime, and they apply across the board to all transactions in the US and all transactions by US persons involving OFAC prohibited countries or OFAC prohibited parties. Now, relating ITAR control versus OFAC controls, the what versus who, unlike ITAR, which applies to USML controlled items, services, and technical data, meaning the what controls, OFAC jurisdiction applies across the board to all transactions in the US and to all transactions by US persons, wherever you may be located, involving OFAC prohibited countries or OFAC prohibited parties. That's the who controls. Regarding OFAC jurisdiction and this who-based jurisdiction, we're looking at US individuals, US companies, foreign branches of US companies, foreign subsidiaries of US companies, so looking at Cuba and Iran only, US-based branches of foreign companies, US-based subsidiaries of foreign companies, and foreign individuals in the US. Now, OFAC sanctioned countries, can I do something with Cuba? Yes or no? Well, you can with a license. Iran, well, not without a license. North Korea, Syria. And it's important to realize that OFAC has general licenses, which means if the activity you want to do is already within the scope of what a general license covers, and there's several of them, then you're able to go ahead and do those activities. Specific licenses, however, require, a specific fact pattern, what you intend to do, describing all of this to OFAC, submitting it to them, and then waiting for them to approve your license or not. Now, it's important to note that in addition to OFAC country sanctions, ITAR has country prohibitions on exports of USML items to certain countries, and EAR has country prohibitions on exports of EAR items to certain countries. In neither case is there 100% overlap. So you can't presume, oh, okay, it's this way with one agency, it must be that way with another. OFAC has list-based sanctioned countries, some list-based embargoes, and we've got a list here from the Balkans to Burma, to Ethiopia, to Iraq, Mali, Nicaragua, Sudan, South Sudan, Ukraine, Russia, Venezuela, Zimbabwe. And OFAC prohibited country sanctioned programs, both the full embargo countries and the list-based countries. They change through what's known as the Federal Register Notice, and changes are effective on the date when the Federal Register Notice is published, unless a wind down period is specified. So similarly, earlier I talked about how the rule had come out, but it was not effective until about 5 months later. So if they specify an effective date as a future time, then that becomes the effective date. Otherwise, the date it's published will be the effective date. Okay. Now, in terms of prohibited parties, there are full or partial embargoes, and there's a bunch of lists that OFAC has, and these help you make sense of, are we prohibited from engaging in certain activities with them, or is there a restriction to engaging in certain transactions with them? So some of the more common ones of especially designated nationals, SDN list, they're prohibited without an OFAC specific license. Deemed SDNs prohibited without an OFAC specific license. The special sectoral list, SSI, also is restricted without, and it may require an OFAC specific license, as are the deemed SSIs and the foreign sanctions evaders list. Now, these parties also change by a Federal Register notice, and changes are effective on the date when the Federal Register notice is published, unless there's a wind down period that is specified. OFAC does have a portal to do screening searches for prohibited and restricted parties. And we talk a little bit about this in a Russia sanctions and diversion prevention webinar we did a couple of weeks ago. It's part of New York's World Trade Week program. And that's over on our YouTube page. I'll share that information in a bit. Now, penalties. I want to stop here a moment and just share a story, because when we think about restricted parties, normally we're thinking about, okay, if I want to export this to such and such country. But a few times during this presentation, I've talked about so-called technical data. And technical data can be something that you have in your US office, that where that information were to be sent to a party considered restricted as a result of their country of origin, then you cannot share that information with them either in your US location, even if they have a valid visa to be working in the United States. This has been an issue we're seeing more and more of, where companies are looking to create a shield, if you will, internally, so that they can avoid penalties. And here's an example here of some OFAC penalties. So civil penalties, $250,000 or twice the value of each non-compliant transaction, up to $1,075,000 per violation. Criminal penalties, $50,000 to $10 million in terms of fines, and jail time may be possible, 10 to 30 years in prison. ITAR also has very serious penalties, up to $1 million plus per fine, for each violation. Personal penalty, so it doesn't stop at the business, it can run to individuals, up to $500,000. And of course, there's also jail time. Now, I know navigating the ITAR compliance maze and even the OFAC one or BIS, which will be discussed shortly, these can be complicated. And so I've got some tips for all of you, starting with tip number one. Understand ITAR regulations, same with OFACs or BIS, even census, where your exports are over 2,500 or not, just by doing your filing because you have exports which require licenses. You want to be sure to identify your controlled items. Those, of course, you need to identify the license exception on your AES when it's going out. Prior to engaging in business, have you screened everybody involved? I know you want to make the sale, everybody does, but can you make the sale? We had an issue with a client dealing with nuclear related products, and somebody on the board of directors was on a list. This list is related to BIS. It was their unverified list. But the question arose, does this restrict us then from engaging in business with this overall entity? So you want to have a process for screening everybody who is involved. And that starts with your, really with your sales export controls questionnaire. Next, of course, is to obtain the proper licenses. You want to go ahead and document the transactions. Of course, you have your record keeping requirements mandated under the regulations. But are there other things that are helpful to what you're doing in terms of the transactions? What else do you need in your compliance program to help you feel comfortable with your compliance obligations being met? And of course, all of that helps to train employees. You want to be sure to train them and to implement secure IT systems. All of this, of course, comes into your documented compliance program, the policies that run with your program. And you want to go back and periodically check, hey, are we doing what we plan to do in terms of our compliance program? Did we find anything that we shouldn't have been doing and now is in need of correction? So you want to look at that. And of course, you want to stay updated. So when we have updates like how these exemptions have been become final, all grouped together. Okay, now I know instead of looking where I'm used to looking, I need to look here. Your compliance manual needs to be updated so that anybody else who comes to work at your company knows where to go and find those. So as a bonus for those of you who are still listening and have stayed here, we do have a bonus 10 tips for conducting ITAR compliant transactions. And you could either scan this QR code or right underneath it, we have the HTTPS website that you can type in, bit.ly/ITAR-OFAC-webinar-bonus. And when you come to this web page, you're going to see something that looks like this. You'll see underneath the image, click here to get your bonus, which is down here. Once you click on that, then this pop-up will come up. Just put in your information and you'll go ahead and click get your bonus now. And when you do that, there will be a button here for you to download it, and you can download the tip sheet, which includes more information than I had time to share in this presentation, which is why I just went over the 10 tips quickly. Now, as a second bonus, because we know of the challenges, we're making a special offer for the first 10 people who go ahead and download this document. They will receive a complimentary 30-minute consultation with our law firm. So for the first 10 of you to go and get this, we will contact you. Somebody will be contacting you either later this week or next week with respect to setting up a time. Okay. Now, as a third resource for all of you, I want to point you to our YouTube channel. Again, we've got the bonus QR code still up on the screen. This is just a sample of some of our dozens of videos. Of course, they're free. They're on YouTube. Go ahead and subscribe to our channel for any updates. But we've got them related to exporting, importing, compliance in general, documenting your processes, creating procedures, what have you. So with that, I'd like to thank everybody for joining me this morning here's a way to continue the conversation with us. You can follow us on social media. We're on Instagram, YouTube, at Clark-Esposito Law Firm, Facebook, and of course, LinkedIn. Our contact information is here, and I look forward to speaking with the 10 of you who took advantage of our offer.
Subscribe and click the bell icon so you'll be the first to know when we upload a new video. Check out our playlist if you want to see more of our videos, and comment below and introduce yourself. We'll see you soon.